Hi, I'm Kenley Hoover, a director with the Biotechnology Group of the intellectual property law firm Sterne, Kessler, Goldstein Fox. The First-Inventor-to-File provisions of the American Invents Act thrust inventors into the race to be the first to file a patent application on an invention and dramatically alters the scope of public disclosure referred to as prior art that is considered when evaluating patentability. The changes brought about by the U.S. First-Inventor-to-File regime demand particular attention when crafting and implementing strategies for protecting one's intellectual property and evaluating the intellectual property of others. These changes particularly impact the biotechnology industry, which relies heavily on patent rights as crucial value drivers for attracting funding, partnering, and protecting its discoveries. As such, biotechnology innovators must modify their patent strategies to adapt to the new law or risk losing potentially crucial patent rights. In this brief video clip, I address issues and challenges confronted by the biotechnology industry in adjusting to the United States First-Inventor-to-File regime enacted under the AIA on March 16, 2013, and some strategies biotechnology applicants have adopted or should adopt to keep in mind in response to these challenges. The United States First-Inventor-to-File status is applied to all applications filed on or after March 16, 2013 that present or have at any time presented a claim having an effective filing date of March 16, 2013 or later. First-Inventor-to-File status substantially expands the scope of the prior art used for novelty and obviousness determinations compared to the standards previously applied under the United States First-to-Invent regime, and eliminates the ability of applicants to rely on their evidence of an earlier date of invention to swear behind a third-party publication. This expansion in the scope of the prior art particularly impacts the biotechnology industry, which relies heavily on communicating nascent ideas to others in efforts to secure funding, attract partnerships, and achieve recognition. Applicants are, as a result, reevaluating their policies and procedures for safeguarding confidential information in view of the heightened risk of losing patent rights due to the expanded scope of prior art under the AIA. Many applicants are reinforcing policies requiring that IP counsel pre-approves the content of all third-party communications relating to proprietary subject matter and emphasizing that all related communications, including conversations, stay within the scope of the pre-approved disclosure. Applicants are also implementing training programs to educate employees on the scope and content of confidential subject matter, the applicant's policies relating to communicating confidential information to third parties, and the importance of their vigilance in preserving the confidentiality of applicants' proprietary information. This heightened risk resulting from the expanded scope of prior art under the First-Inventor-to-File regime has likewise led applicants to retool their record-keeping systems in order to document, date, the content and nature of public and non-public communications of proprietary information by applicants, inventors, employees, collaborators, and third parties. The United States First-Inventor-to-File regime provides clear and distinct advantages for applicants that file patent applications as early as possible and that consequently obtain both the earliest effective filing date and the earliest effective prior art date for a later filed U.S. application. In response, applicants are streamlining their timelines and procedures for identifying, evaluating, and prioritizing IP, and for preparing and filing applications as quickly and as completely as possible. Applicants are also implementing training programs to ensure that employees are able to readily identify IP having potential commercial and strategic value to the applicant, to understand the process and objectives associated with completing an invention disclosure form, and to appreciate the importance of working closely with IP counsel to rapidly prepare and file a comprehensive patent application. The combination of the urgency for filing applications quickly and the uncertainty associated with how the new law will be applied by the PTO and the courts brings additional challenges to a biotech industry searching for guidance in the wake of recent case law that raises uncertainty relating to patent subject matter eligibility and written description requirements, as well as obviousness standards for biotechnology-based inventions. In response to these challenges, many biotechnology applicants are adopting variations of rolling provisional application filing strategies, in which the disclosure of each provisional application filed sequentially over time expands upon the disclosure of the preceding filing in order to, for example, incorporate additional data and descriptive support. Each provisional application filed according to rolling provisional strategy serves both to establish or provide strengthening support for an early effective filing date, and also to act as a defensive publication by providing an early effective prior art date. In conclusion, the First-Inventor-to-File patent system places a premium on maintaining confidentiality, rapidly and efficiently preparing and filing patent applications, and exercising vigilance and diligence while juggling the uncertainties and nuances of the new patent system. The implementation of the strategies I've discussed will help biotech applicants when navigating the juxtaposition between the new and old system that will exist for at least the next decade. Moreover, given the sweeping and radical reform brought about by the AIA and the uncertainties associated with how the rules will be interpreted, applicants are best advised to monitor developments in this area and adapt their strategies with the advice of IP counsel to address these developments as they occur. I'm always available to assist and counsel you on these matters. For more information relating to how the implementation of the AIA will impact your patent portfolio and the strategies being applied by others and your competition in response to the AIA, please visit the firm's website at www.skgf.com. Thank you for listening.